Hello, everybody. Hello, C-Rex. So good to see you. Hello, Eileenie Carlin. You are here. Hello, Sherry B. Oh my gosh, I've missed you. So good to see you. It just took me getting my schedule all mixed up and having to come on for a day live. So happy to have you here. Did I see Salty Buddha? I see the name Salty Buddha. Oh, I see. I see what you mean. I see what you mean. You're just calling out everybody that we miss. And we do miss you guys so much. Ava says she needs her friends. And she needs her treats. That's Ava for you. How cute you are. So cute. Yeah, I have to go get my daughter today, and I was getting stuff ready for tonight since I couldn't come on last night. I was supposed to leave much earlier than now, so I thought I'd sleep, and I didn't. I wasn't feeling very well, so the day got delayed, and I'm here now. And I'm going to run something now, and hopefully I'll run something again tonight after we get back home and all settled. And thank you so much. and it's not, the only difference is that room out there is a little brighter because it's daytime, but the curtains are all closed in here, and I don't know what it is. Terry Barnes, my big Kentucky hugs. Good to see you, sweetie. Mwah. All right, guys. I'd love to have one of those days where we just sit and chat the whole time. But like I said, I got to go get my baby girl. So I came on here to show you some fun that I found. Ava helped. We're going to get into it real quick. What? You had 3. That's all. You're done. Hello, Catherine Gaston, sweetie. All right. I know where I put it this time. Got it.
Good morning. We are on the record in the matter of People versus Latavis, Trishad Thornton. This is case 25-0203-FY. May I have appearances for the record, please? Mr. Inez?
George. Thank you, Andrew. George in the back for the people.
Thank you. And Mr. Thornton, could you state your name for the record, please?
I am Shoulders in here by way of Executive Office for Latavius Trishad Thornton nonprofit organization.
Accept that as Mr. Thornton announcing his appearance before the court. We are here this morning for a pre-exam conference. Mr. Anid, it is my understanding that Mr. Thornton has declined representation. However, Mr. Thornton, at every appearance, I need to remind you that you have a constitutional right to be represented by an attorney, and that if you can't afford an attorney, the court will provide one for you. I am particularly proud of the superb public defenders we have in this court. However, you may also retain any attorney you wish. You will get to choose the attorney. You would have to pay them. You have a constitutional right to represent yourself, but I have to warn you that if you proceed representing yourself, you would be held to the same standard as all attorneys who have gone to law school, passed the bar, and been admitted to practice. So the court really can't give you any breaks or help you at all. Is it your wish to represent yourself, sir?
Thornton is aware of the courtroom decorum and the standards and procedures that must be upheld by a person in representation of a party. And as again, I shoulders, I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used, and to and to forgive me, and to uphold the proper standards. Mr. Thornton does not wish to get public counsel representation for, as I am a legal representation by special appearance through the executive office for Mr. Thornton and not the actual entity, Latavius Cheshire Thornton. Once again, on the record, it has not been declined that Latavius Cheshire Thornton is a nonprofit organization, which, yes, Your Honor, is a person, in fact. And I, the man speaking with a voice and
Okay,
a
so
sound
I'm
mind.
going to cut this off. I don't want to mute you, but we have to move forward. So we have an attorney standing by. That would be Mr. Foreman, who is a very, very good public defender who is available to you. At this point, Mr. Anid, this is the time and date set for a pre-exam conference. Have you had an opportunity to speak with Mr. Thornton about any plea offer?
No, Your Honor, and I don't think I'll have any meaningful conversations with him based on what I see. I believe that it's not clear whether what he's doing is intentional or whether this may be a competency issue. But I'm prepared to proceed. I just don't know if we should. I have a concern for his competency, to be honest with you.
Maybe it's a little of both. Maybe he's somewhat incompetent and he's doing it on purpose.
If the court, we had the same issue all this time.
No, Mr. Thornton, one person at a time. And right now, Mr. Anid is speaking.
I mean, I guess I would inquire with whether he knows what a preliminary exam is, and if he understands, if we forward, if he's gonna know what to do. I mean, I believe I have to look at the court rules. I've never dealt with this issue, but I think having standby counsel would be something that would be needed to advise him. I'll look into all that, but I just don't know if he's gonna know what a preliminary exam is. I believe this may just be a competency issue. I don't know, Your Honor.
Okay, so actually that's a good question. So Mr. Thornton, I'm going to ask you, what is a preliminary exam?
Well, before I address that, may I address
No,
it to
sir.
you?
No, we're gonna focus our answers here. What is a preliminary exam?
Your Honor.
I'm going to give you one chance to answer. What is a preliminary exam?
A court proceeding.
Okay, and what? Okay, and what happens? That's a good answer. What happens at that court proceeding?
At a preliminary examination court proceeding, the parties have the opportunity to present evidence, cross-examine each other, and determine whether a case is, whether evidence is admissible to go into continuing proceedings, whether the court has jurisdictions. A plethora of matters may be brought up in a preliminary examination to see if the court has a valid standing, to see if there's anything, to see what may be addressed that's necessary as far as the parties that are at hand, not only to go about things in one specific fashion.
Well, that's pretty that's a pretty good answer. However, at this point, given a review of
Your Honor,
history, the court is going to sua sponte suggest that a competency exam be ordered. Mr. Anid, any response?
I agree.
Okay, thank you. Mr.
Yeah.
Thornton, any response?
Mr. Thornton does not believe that a competency exam sua sponte is necessary and objects that as a preliminary exam is something that we can proceed to. And and we can address the matters and the situations that are necessary at that time. And for the sake of due process and the judicial precedence of due process, that a criminal or a competency test may delay that, and it could hinder not only Mr. Thornton, but the things that Mr. Thornton does as far as the community and his career and his family and his life and rights, and other people that may be affected by this matter, as well as the public. Because for the judicial precedence is that Mr. Thornton is innocent and not guilty.
So, Mr. Anid, are you going to prepare a proposed order, or?
Your Honor, I think it's been a while since I've done. I believe if I'm not mistaken, it's the. I can if you want. Yes, I'll prepare an order.
All right. So, at this time, Mr. Anid, comments on the preliminary exam?
Nope. I just say we just make the preliminary examination to be determined date. If anything, reset it for another PCC or review hearing for when we do come back with a competency opinion.
Okay. So, Mr. Thornton, you have two rights at play here. One is the preliminary exam that we just discussed, and the second is the right to have that within 21 days. So, the reason that you have a right to have that within 21 days is to prevent cases from dragging on endlessly. There are certain timelines that have to be met. However, the court can waive that 21 days if it finds good cause. And that would be, for instance, if one side had recently received discovery and was unable to proceed. Another good cause could be if someone was ill or hospitalized. There could be any number of good reasons. So I'm going to ask you, actually, Mr. Thornton, have you received any discovery in this matter?
I have not. Mr. Thornton has not received any instrument.
Okay, so, all right, two things then. First, I find good cause to waive the 21-day rule, and we will get a date. No, sir, just a minute, let me finish. You don't, no, I don't want to mute you, but I have to get through this. So, you have to have, you have a constitutional right to have knowledge about your case. And if you haven't received any discovery, we can't go forward until you receive it. So two things. First, I'm going to waive the 21-day rule. And just a minute, Mr. Sid. We're going to waive the 21-day rule, and we're going to set a date out in about a month. That'd be a placeholder date. As soon as we get that date, then we'll go to the discovery issue. So next up, where we're going to adjourn this case we're going to adjourn this case to I just lost that chat, to a probable cause conference at 8:30 a.m. on April 25th. And a preliminary exam date of 9 a.m. May 1st. Now, Mr. Anid, you wanted to be in a breakout room with Mr. Foreman. I'm guessing you want to discuss discovery. So.
And you, Judge.
With me, or you want to discuss me?
All three of us really quickly. That's okay.
Okay.
I will like
do that. Okay. Just a moment, Mr. Thornton. We'll be back in just a moment. Okay. Thank you.
Thank you, sir, for waiting. The judge and the attorneys will be right back in shortly.
All right, we are back on the record in the matter of People versus Latavis, Trishad Thornton. This is case 25-0203-FY. And for a moment, at Mr. Anid's request, the court, Mr. Foreman and Mr. Anid discussed standby counsel. So standby counsel is something with certain mechanical concerns. So For standby counsel, the court can't just appoint standby counsel. This is what we discussed in the breakout room. The court, or perhaps its funding unit, the city of East Lansing, would have to enter into a contract with the public defender's office. And if both sides agreed to that and a certain financial rate, then an attorney from the public defender's office would sit next to Mr. Thornton and be available to advise him during all proceedings. Back in the day, when I was on the court appointed list, a judge could just appoint someone and do it. That doesn't exist anymore because of the MIDC. So we discussed the mechanics of that. The court is going to make a formal discovery request on behalf of Mr. Thornton. So Mr. Thornton, you should receive at the jail, or if you post bond at the address we have on record, all of the materials that a defense attorney would receive that the prosecutor has. At this point, Mr. Enid would like to speak with Mr. Thornton and perhaps see if a plea deal is possible. So Mr. Thornton, you never have to accept a plea deal, but it's worth listening for two reasons. First, there may be something there that you can reach an agreement on. You have a constitutional right to have these charges heard at a trial. Sometimes you can make a bargain, something that is worth giving up your right for a trial, for instance, a lesser charge, a lighter sentence, or both. The other side is you kind of want to know what the prosecutor's thinking about the case. Like, as a defense attorney, I always wanted to hear what the plea offer was. Even if my client was absolutely not going to take it, it gave me some insight into where the prosecutor was interested in going with the case. Again, you were never required to accept a plea bargain. At this point, because you are representing yourself, I'm going to allow you to converse with Mr. Enid, recognizing that you do not have discovery materials, so I do not expect this court to accept a plea bargain today. All right. We're going to put you both in a breakout room, and when you're done, the court will be ready. Thank you. Okay, let's see. There we go. All right, so we're going to wait until the sound is back on in the jail for Mr. Thornton, and then we'll resume. Okay, sound is back on at the jail, so we will go back on the record in the matter of People versus Latavius Rashad Thornton. This is case 25-0203-FY. Mr. Enid, prosecutor, and Mr. Thornton, representing himself, have met in a breakout room. So first, because the prosecutor has burden of proof, I'm going to ask Mr. Enid first, then Mr. Thornton, I'll ask you. So Mr. Enid, anything from the breakout room that you'd like to report?
Yes, I just want to make sure Mr. Thornton is there because I don't see him on here.
Oh, I see him.
Okay. Can you hear me? Okay. Yep. So we discussed. Yep. We discussed a little bit of as much as we could. I believe based on my discussions with him, I don't believe this is a competency issue. I believe this is more of the what Mr. Thornton kind of described earlier. So the plan, I think we both agreed on, is we're asking for another probable cause conference. I'm going to somehow figure out how to provide him discovery, the complaint, the information, all the charging documents that we have. We're going to come back. In the meantime, I'm going to do my due diligence to speak with our office to see how we're going to go forward with this. Because I know it's my understanding he wants to represent himself. That is his right. I believe based on the questions that you asked earlier, he answered them pretty fairly, Your Honor. I just want to make sure we got all ducks in order. I discussed a misdemeanor offer potentially with them, but also discussed that I encourage him to get a public defender. All these things I think we're going to discuss at the next probable cause conference. I think these are all appropriate matters so I can get my ducks in order. He can have discovery to know what he's looking at. And I believe at the next hearing, we will have a good understanding of what we're doing going forward.
Mr. Thornton, is that an accurate report?
It's pretty accurate, Your Honor. Just a few more points that we had discussed in that breakout room was also that it was in the discovery, we would like to get subject matter in the appointment of the authorities that has been filed onto the record for these proceedings and how we came about to be into the court's jurisdiction for this matter in such fashion. And I think
Sorry,
that's kind of what
that's a word salad. It's not making any soup. Can you
And-
make sense at all? Can you rephrase that for me? Mr. Thornton. Mr. Thornton, please.
Yeah. So just pretty much all in the discovery, we didn't want any documents that have been filed onto the case to be missing, and that's and that's not that's what I mean by not limited to the documents titles that he named. It include an inclusion of all documents filed with all titles under them.
And
Okay.
I'll
Yes,
chime in
Mr.
here.
Ned.
And I think kind of what he may be talking about is, and I could be wrong, is the charging documents, what gives us the authority to proceed forward and how we're proceeding forward. And I explained you should wait until you discover it, because I believe that's going to be the complaint, the information, and the other charging documents to see where we're at. I could be wrong, but once he receives those, we'll come back. We'll have all the ducks in order. I think that's a good resolution we both agreed on. And in the meantime, I'll do my due diligence to speak with our officer how we're going to go forward. I told Mr. Thornton, I'm the prosecutor. He understands what the prosecutor is. I'm not on his side, but I did advise I'm here to help get the situation resolved as fast as possible. And I think we both agree that if you find good cause to adjourn this for one more probable cause conference, I believe everything will be situated. The only thing I have to ask is, how do I provide discovery to Mr. Thornton?
I would guess that you could mail it to him, or yeah, I think
I'll figure it out. I'll ask my office.
communication through the jail.
Okay.
At his address through the jail, and it may have to be paper communication.
Okay. I'll do my due diligence today when I get to the office today, Your Honor.
Okay. And yeah, I don't have discovery demand in front of me, but that would include, of course, any exculpatory materials granted under Brady. That would include make a request for any body worn camera, any evidence you plan to introduce, any car video, any report that you have in your office other than was protected under attorney-client privilege with the prosecutor or any. Mr. Thornton, anything further this morning?
Not at this time, Your Honor.
Just new dates, Your Honor. New dates. New probable cause.
Okay, so we had the dates, and that is 8:30 a.m., April 25th, for a probable cause conference, and 9 a.m., May 1st, for a preliminary exam.
Okay, so the next probable cause conference is about a month away. Does that sound right?
Yes.
Okay. All right.
So, Mr. Thornton, if at any time you change your mind, you can communicate with the court and or Mr. Anid about requesting counsel. At every hearing, I'm obligated to tell you your right about counsel and to determine the parameters of that. All right, so we will see you back at 8:30 a.m., April 25th. That is all.
Thank you, Your Honor.
Thank you.
Take care.
Thank you.
Take care, Mr. Amid.
Thank you.
I will be looking forward to it. Now, this next one, you guys, I just want to remind you, please be kind. The defendant has a traumatic brain injury. So their speech is off, their behavior is off, but it's nothing that they can help. The real focus and, the substance of this case is pretty much on the judge, because the judge is watching out for this guy. Thank God.
Does that leave us with Mr. Seibel?
Let's see here. Well, I don't see Mr. Hartel here.
I am Mr. Hertel.
Wow. All right. You've got a couple people here in the courtroom. Maybe I can get rid of them first. Say, when I say get rid of them, I mean that in an appropriate professional manner. All right. Mr. Harrison, who else is in here?
Mr. Hamilton is the most eager.
Mr. Hamilton? Why don't you go ahead and come on up, sir? Okay, thank you, sir.
Okay.
We have the wrong prosecutor.
You're the wrong process.
Oh, we do?
Mr. Carnes was a.
All right, well, you know what? When I try to do things smoothly and efficiently, it ends up a little bit like Elon Musk, and I get it wrong.
Just
So,
stay right there.
sorry, and by the way, I'm just saying that to be joking.
I'll notify Mr. Musk that this was not of your making.
I'm gonna fire somebody, rehire them back.
Good guy.
No, that's okay.
All right. All right, well, there's a couple of people over there. Are you all together? Yeah.
Oh, there's Mr. Carnes right there.
Oh, never mind.
Musical chairs. I had no idea. All right.
I do. You ready?
I'm ready.
Joshua Hamilton,
Yeah.
2513995. All right, we're taking up next the case of people in the state of Michigan versus Joshua Hamilton. This is case number 25-13995FH. Appearances, gentlemen.
Nate Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Hamilton. He has joined me at the table.
All right, gentlemen, thank you very much. We're here today for a final pre-trial conference in this case. This is one of several set for a potential trial on April 8th. And what are we doing today?
Your Honor, it's my understanding that defendant is going to enter a guilty plea to an added count of attempted felonious assault. The people are going to dismiss felonious assault and resist or obstruct a police officer. Additionally, there is a Killebrew agreement for no additional jail at the time of sentencing if defendant remains compliant on bond. Okay.
All right, thank you. Mr. Harrison?
That
Is that-
comports with my understanding of the plea agreement,
Okay,
as well as that of Mr. Hamilton. I want to tee this up for the court. As you can probably tell from his demeanor, he's very enthusiastic. And sometimes he has a little trouble focusing. He suffered a TBI several years ago.
I recall.
So if you'll bear with us,
Yeah.
it may take some patience to get through this.
Mr. Hamilton, you and I are going to be doing the talking now for just a couple minutes, so bear with me. All right, please raise your right hand, sir. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
I do.
You may lower your hand. Mr. Hamilton, are you on probation or parole anywhere?
No, it's my first offense on anything
Okay.
bad. I never,
Okay,
I try not to get in trouble. I'm 43 years old and I've never been in trouble. I don't miss court.
it's okay. It's all right.
I graduated high school, I graduated college.
It's okay, Mr. Hamilton, it's all right. Hey, Mom, it's all right. I'm patient. Don't worry about it. I'll do my best here. All right, Mr. Hamilton. I'm told today that you're gonna plead guilty to a count. Is that correct? Yes or no? All right. Now, before we do that, I need to go over some information. Now, right now, you are charged with 2 offenses. The first one is called assault with a dangerous weapon, specifically a handgun. Now, that's a felony punishable by up to 4 years and or up to $2,000. However, that count will be dismissed if you plead guilty to a lesser charge. That lesser charge would be attempt to assault with a dangerous weapon, which is a felony punishable by no more than 2 years and or no more than $1,000. You understand? All right. Now, count 2 is going to be dismissed, but I haven't told you what that count is yet, but I will now. Count 2 was that you allegedly assaulted, resisted, or obstructed a police officer in the performance of his or her duties. That is a felony punishable by up to 2 years and or $2,000. However, that charge will be dismissed. Is that what you understood?
Is that what we're gonna do, lawyer?
That's what we talked about.
Yeah.
Okay.
The R would be dismissed.
Yeah,
All right, Mr. Hamilton.
I don't like felonies. I've only had one misdemeanor.
Okay,
I'm trying to say be good. I'm
okay,
a hunter
I
and a
got it.
fisherman.
It's all right, Mr. Hamilton. Now, sir, if you plead guilty to this lesser charge, you're not gonna have a trial of any kind. Does that make sense? Yes or no?
Yeah,
All right. By pleading guilty, you're gonna be giving up certain rights that you would otherwise have at a trial. Now, that includes the right to be tried by a jury, the right to be tried without a jury, in other words, just with the court, if the prosecutor and the court agree, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have silence used against you, and the right to testify if you chose to testify. Do you understand those rights, Mr. Hamilton?
yeah,
And do you understand that if you plead guilty in just a moment, you will be waiving those rights and we won't have that trial?
yeah, as long as I get this done, all right.
Okay, all right. Now, furthermore, if this court accepts that plea, any appeal as to the conviction and sentence pursuant to this pretrial agreement will be by filing an application for leave to appeal and not a claim to appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Also, if I accept that plea, you will be given up the right to claim that the plea was a result of some other promises or threats or inducements that you haven't told me about. Have there been any other promises other than the thing about the sentencing, which I'm going to get to? Has anybody else forced you, pressured you?
No, here, my will, free will.
Okay, and are you going to enter this plea of your own free will?
Yeah,
Okay.
yeah,
Now, there's this other portion of this agreement that I haven't explained to you yet, but you heard the attorneys talk about it. And that is there's an agreement at sentencing. Now, that agreement is between you and the prosecutor alone. And that is that at the time of sentencing, I won't give you any jail. I know you've already done some jail, but I won't give you any additional jail. Now, if I don't go along with that, you would have the right to withdraw your plea and then go back to a trial. I have no reason to think that I won't, but the real condition here is that the prosecutor is going to stick with that agreement as long as you are compliant on bond, which means between now and sentencing, which will be about a month. Do you understand?
yeah,
Can you make it a month without getting in trouble?
yeah, I'm not troublemaker, Your Honor.
Okay, okay. All
I
right.
don't mean, is your wife Dr. Elmore?
Yes, she is.
That's my doctor.
Okay, all right. Well, great. I hope that she's a good doctor for your
Yeah,
mom.
no, she's awesome, doctor.
I am well aware she's awesome. Thank
She's
you.
getting ready to retire.
All right. Well, anyways, do you still wish to enter the plea?
Yes, I
All
need
right.
to get this taken care of.
As to the added count 3 of attempted felonious assault, how do you plead, Josh?
Guilty.
All right. Now, before I can accept that plea, I've got to have you tell me what it is that you did that makes you guilty of the offense.
That's only one charge, all right?
Yep, that's
Okay.
it. So hold on. Looking back in November on the 22nd, right around Thanksgiving this past year in 2024, out in Antioch Township, way up there by Mesick here in Wexford County. What happened between you and Mark? Who's Mark?
My brother, he's my older brother,
Okay,
and he kicked I said some things that I probably shouldn't have said out
Yeah.
loud. And he kicked my door in and wanted to fight.
okay,
And then he threw my lunchbox and hit my lockbox, which had a gun in it.
okay,
So the gun hit the floor, I had to pick up before he did.
okay,
I just asked him to leave my room.
okay,
That's only how the gun got involved.
all right. And so when you said you picked up the firearm
Yeah,
and then you pointed the firearm at your brother?
yeah, and the gun.
All right, and did you say anything to him when you pointed the firearm
Yes, I
at him?
asked him, please leave my room.
Okay,
But then I just sat down, I didn't wanna hurt him.
yeah, okay, all right. Did you hit him at all with the firearm?
No, I was scared, cause
And why did he come into the bedroom?
I think I was mouthing off about his daughter.
You were mouthing off?
Yeah, she don't go to school.
Okay,
My dad raised me, you better go to school every day. I graduated high school.
Good,
Amazing.
good.
And I was pounded in my head, go to school.
All right, thank you, Mr. Hamilton. Just one moment here. I now need to speak with the lawyer.
Okay.
Come on. Is that what happened, or am I missing? I'm gonna allow you guys to ask some questions.
That is
So
very-
far, yeah, could he use deadly force versus non-deadly force? But he didn't discharge the firearm, so it's not deadly force, it's a threat of potential deadly force. I've got that, but
That's the intent.
all right. Are there any other questions for Mr. Hamilton? Yeah, because I don't know, I don't have the police report. I don't know what the allegations are. I assume because Mr. Hamilton said he would tell the truth, that what he just told me was the truth.
It was.
Okay, I don't know worries, Josh. Hold on.
Well, let's get a couple of things perhaps clarified. Do you know what that means?
Yeah.
Okay.
Clarify, yeah.
Okay, so you picked up the gun and put it in Mark's gut,
Yeah.
okay?
I just pointed at it, it's good, I didn't know.
Okay,
Did you push it into his stomach?
No,
All right.
I didn't even cock the hammer because I knew I didn't wanna hurt him.
Was there ammunition in it?
Yeah.
All right, keep going, Mr. Harrison.
would he have had reason to be afraid that you might shoot him at that point?
No, not my brother, he knows I want to shoot.
Okay, you pointed a gun at him.
Just for he to leave my room, he's attacking me.
This sounds like everyday brotherly shenanigans, usually in the teenage to, early adult life stage. But yeah, when you have brothers in their, 30s, 40s that live together, it can still happen. Especially if he was talking smack about the other one's daughter. I think the weapon was just an unfortunate accident. I don't think this was intentional at all.
He's done this 3 other times by kicking my door. This ain't the first time it's happened. My stuff gets broke, only my stuff. I don't go to his room.
Okay, hold on, Josh. Anything else, Mr. Harrison? If you're looking, Mr. Harrison, I'll wait. Take your time.
I am looking.
All right.
It seems to me that there was some verbal exchange at the scene concurrent with the pointing of the gun, but I'm not finding it in the police report. And
Well,
he
let's
clearly doesn't remember.
Well, that's all right. Let's wait and see what Mr. Carnes brings up.
Josh, is it true that when your brother Mark entered your room, he asked if you could be quiet because his daughter Emma was studying?
Maybe, I don't remember. He could have.
How big is your brother, Mark?
5'6".
So he's shorter than you?
Yeah, he's shorter than me, so.
Okay. Have the two of you ever been in a fight before?
No, we've always been close, that's what I don't understand. We're both iron workers,
Iron workers?
local 340,
Okay,
Battle Creek, Michigan.
all right. So you said he's come into your room and kicked the door in before. Tell me about that. When was it?
Months before this. I mean, months before, you know what I mean? Hey, a couple of months, wham, couple of months, wham.
All right, and so what happened those prior times?
I just asked him to leave and he did.
Okay.
I
Why?
stay quiet, then I guess I have a problem with my mouth. I'm loud.
So why did you not ask him to leave this time, or did you?
I did, and he wouldn't leave. He picked up my weight and was gonna swing at me.
And how did the gun fall out of the box?
It was in a lockbox right here. He threw my lunchbox and it broke open and fell out.
So you didn't go retrieved the
No.
gun out of the box. You just
No.
picked it up off the floor.
Before he got it.
Okay.
It was my room that we're in, and I was quiet after that. I didn't mean to cause family ruckus.
That's okay. I've got it. Well, let's look here at the definitions for the elements for self-defense and use of harm. From what I'm hearing, it's not like he ran and grabbed the gun, opened the box, grabbed it. He picked it up so nobody else would pick it up, but then he used it and brandished it. He didn't brandish it in public. So we're looking at court and jury instruction. I think it's 7-2.
I was just scared, Your Honor. It's
okay.
My bigger brother.
Hold on.
Older brother, not bigger. Always taught to respect the elders.
Hold on, Mr. Hamilton.
Yeah.
Mom, don't worry. He's doing well. Did you think, Josh, Mark was going to do?
He was waving around my other gun at me, trying to hit me with it.
There was another firearm?
Yeah, my way, but
Where was that located?
laying up against my door.
Did he?
Yeah, he
Did-
brandished it. He
Hold on.
brandished it.
Hold on. Did he hit that firearm first? Or did you who picked up a firearm first? You
I
or Mark?
did. I did. The one that broke out of ground, and then he picked up the way he was gonna break it. I don't know if
Okay.
he wanted to, he didn't aim it at me, but when he was like this, it was aimed at me. You know what I mean?
I got it. Thank you, sir. Okay. Accepting this plea.
I would accept the plea to resist or obstruct a police officer.
Jeff, why don't you talk about that with him? There's no way that, yeah, anyways. Jeff?
Okay. Did fuck it up for us?
Nope.
Okay. Do you want to talk for another minute outside of the court?
Yeah, I fucked it up.
No, hold on, Josh.
Stop with the F word and don't worry about it, okay?
I'm not used to you guys
It's
two
okay.
guys in the courtroom.
Everybody's
I'm not
yelling at
used
you
to
too,
it.
okay?
Yeah,
All right,
Step
off the
out the
record.
hallway and I'll talk to you for a minute, okay? With
okay.
your mom. Go talk to your mom for a minute,
Yeah.
calm down, okay?
Yeah, I can do
Okay.
that. Thank you, Your Honor. I don't mean to rise before you.
We have a brief adjournment, Your Honor.
All right, back on the record there.
I don't need to rise.
All right, so we went off the record just briefly,
Thank
so
you.
Mr. Harrison could speak with his counsel. There's
Josh, you didn't do anything wrong. Oh my goodness. No. The judge is trying to save your bacon, boy.
client. We're going to take a brief recess to allow Mr. Hamilton and Mr. Harrison to talk. I think that's appropriate. We will recess on that file.
As long as I get out of here. You know, I don't like quirky late. But ain't that I don't like him.
I understand.
I'm scared of him.
Everybody understands.
He's the only one that can take my freedom.
All right. You ready?
Yes.
Back on the record now for the 28th Circuit Court here in Wexford County. And we're going to recall the case of People of the State of Michigan versus Joshua Hamilton, 25-13992. I think parties that were here previously are getting back here on the record. What are we doing, Mr. Harrison?
We are unable to achieve any resolution of the case, Your Honor.
Okay.
Mr. Hamilton is aware that will result in the case being set for trial, and it could be as soon as April 8th.
I'm pretty sure we have another trial.
I am
set for
too, but
April.
I didn't want to leave any stone unturned.
It
But I-
said April 8th on my letter. I don't know, 9 o'clock.
I know. All right, so April 8th is set for one day for the other trial.
I think that's Mr. Burdett's client.
So my question is do I put this on April 9th and Wednesday?
This would otherwise be the oldest case, would it not?
No. Look, this one's way down on the line.
Okay,
So
There are a couple other matters that are yet to be presented to you that I also believe will be set for trial.
All right, so here's what I'm gonna do. I am going to keep it on the current trial date. The likelihood of it going on that date sounds relatively low, but we'll make a decision in case something happens. I don't want to lose a trial date. And so we'll just go ahead and leave it.
I'll be here. It says I'll be here.
Mr. Hamilton, I have no doubt you'll be here and I'll look forward to having you here. Okay, sir?
Thank you. Respect, brother.
All right, thank you. All right, we're adjourned. Bond
Thank you,
continues.
Ron.
Yep,
Thank you.
thank you. Josh, you're free to go. Have a good day.
Yeah, thank you. We'll see you in April 8th then.
All right, thank you,
I don't
sir.
want to clear this up. I'm gonna get in more trouble like when I try to clean up something, it just messes up everything. Yeah, but hopefully some good could come.
All right, are we good?
Oh, yeah. Yeah.
I do have Mr. Burdett's next file, and isn't there two?
You're the one that gave me mine, George.
All right,
I love that judge for that exact reason right there. He's so patient and he's kind, and he will not take a plea if he feels like there's any chance that the defendant is not being given all of their rights, or if they're, I don't want to say being coerced into it for simplicity's sake, but that's kind of the only thing that comes to mind, where it's like, okay, just, take this plea so we can brush it under the rug. And yeah, there's gonna be more of that judge tonight, and at worst case scenario tomorrow. I'm hoping to be back early enough to stream tonight. I've already got it done. I just have to double check it, and then I can run it. So I am off to go get my daughter. Yay! I have oh my goodness, I'm so excited. I have a replay crew mini scheduled for 6:30, so be ready for that one to pop up. And other than that, I hope I get to see you guys all again tonight. This has been a fun day shift. Hopefully I'll get to do this more often. Thank you guys so much for coming and joining me. Ava's happy. She got treats, and she got one of those chew sticks. Yeah. There's my girl. There's my good girl. Everybody's love. All right, guys. Be safe, be well, sleep sweet, and much love.